than if I were doing this. Is it okay? Okay. Wait a second. Got it. This is stranger than if I were doing this by Zoom, because I can't see you very well. I see you, I look on the big screen and I'm looking at the screen in front of me. I don't see you. So it's even worse than doing this via Zoom. And I've always done this. That's better. I've always, if you guys can, I mean, I know some of you don't want to, you're having, like me, you may be having a bad hair day and you don't want to put your photo on the screen, but it would be nice to see you if you're comfortable doing that. Because I think you can hear me certainly, and you can speak to me, which is good, because I prefer to do this in an interactive way, and it's unfair to the 3 people in the room that they have to be the ones answering all the questions, but there's going to be a lot of pressure on them. Right now their mouths are full with sandwiches, but that's no excuse. Yeah, as Valerie said, I'm American. I've been practicing in Brussels nearly 40 years. So now I've taken Belgian nationality. I'm also a member of 3 different bars. I'm the only person I know who's a member of 3 bars. I'm a member of the Georgia bar in the United States, because as you know, in the United States, there's no such thing as the American bar. There are 50 different bars for each state. Actually, I think there may be 51, because District of Columbia, I think, has a separate bar. And then I'm a member of the Bar of England and Wales. And I did that about 20 years ago, which allowed me to plead in the European courts, because I got tired of giving away my cases to my colleagues every time it got to the court. Some people, and I'm a solicitor, some of my, at least Americans, they don't understand the difference between solicitors and barristers. And they think I became an English lawyer so I could wear a wig. And I explained to them it's because the solicitors don't wear wigs, it's barristers. But in any event, so I'm also a member of the Bar of England and Wales. But then since Brexit occurred, I then had to become a member of the Belgian bar, the Brussels bar, which actually was fairly easy, because the Brussels bar did everything it could to make it easy for people like me to then join the bar. So basically, we just had to go do a swearing-in ceremony at the court, and we were in. So it was nice that they were, helpful on that. It also helped, of course, that I had Belgian nationality to be able to do that. So here I am with 3 bar memberships. Today, we're going to be talking about horizontal agreements. My presentation, to some extent, overlaps with what you heard last week, but that's okay. I mean, if you hear it twice in a different way, it's okay. Part of it overlaps, part of it doesn't. So the first part we're going to do will be kind of a general introduction to horizontal agreements. And then I'm going to move, there are 2 specific kinds of agreements I want to cover in this session: R&D agreements and joint purchasing agreements. And as Paul told you last week, the rules in this area are currently under review by the Commission. So it probably won't be next year, but it will be, because they're also revising the vertical rules, and they're further ahead right now in revising the vertical rules. The vertical rules will certainly new rules will come into force next year, but the horizontal rules won't be far behind. And as you can imagine, there's a fair amount of lobbying going on by different companies and law firms dealing with the revision of these rules. In what we're talking about today, there's been a fair amount of lobbying on the joint R&D rules, because the current rules are extremely technical, and sometimes they don't really make sense. I work with them a fair amount because I do a lot in the pharma industry. And once you get down in the details, some of the rules just don't make a lot of sense. So there's some lobbying to try to make them a little clearer. There's also a fair amount of lobbying on standards, which we're not talking about today, but companies that have in the IT sector that have a lot at stake with standards. They're lobbying heavily on that. So the rules are in the process of changing, but I wouldn't expect that the changes might affect maybe 10% of these rules because they've been revised several times. So I wouldn't expect any major changes from what we're talking about today. So conceptually, everything's pretty much the same. The changes will be more on details on the edge. Please don't hesitate to stop me anytime as we're going along. I mean, those of you who are, most of you are coming in via Zoom. So, I think you can write questions, but you can just say the question and we'll discuss it. So please don't hesitate. I would like to make this as interactive as possible. So I'm starting out with, if I can figure out how to do this. How does this move? See, it's not just me. Okay, now it's okay. Click twice. Okay, that's tricky. All right. So I want to start out with a hypothetical, okay, and just to kind of talk this through. So the hypothetical, you have a term sheet, and typically with a joint venture, you're going to have, your client is going to give you a term, hopefully they will give you a term sheet because normally you and the legal department are supposed to be drafting the agreement, right? So you're probably going to do the term sheet actually. Those of you who are in-house, if you're external lawyers, your client will send you the term sheet. And hopefully this is the first thing you see. So you see this early in the process because it's important, and those of you who are in-house, it's important to tell your business clients that they should come to you at this phase, at the term sheet phase, when they start talking to the potential partner, because the things we're talking about today can affect the structure of first of all, it can affect whether they can even do the joint venture. Okay, that's the first question we'll talk about, but it also could affect the structure of the joint venture. So the earlier they come to you, the better, because it's easier to change the structure early in the process rather than waiting until they're far along in their negotiations with a partner. And then they come to the legal department, you say, well, wait a minute, I'm sorry, you're going to have to change this. And that can cause all kinds of, obviously political problems, both internally and with your partner. So our example, in this example, is a 50-50 joint venture. And by the way, I haven't given you the presentation. You'll get it at the later, okay? But this way, I can ask you questions and you can't see the answer, which is on the next slide, right? So it's 50-50 joint venture between Air France and Oracle. The joint venture involves the setting up of a systems house, which will provide IT services specifically tailored to the needs of air transport. So just think in terms of, for instance, a reservation system, okay? And before they entered into this joint venture, I mean, Air France IT department was already doing this. So they had their reservation system that their own IT had come up with. It's very specific to Air France and to air transport, but they also sold this system externally to third parties, although they didn't, that's not the main business, obviously. Air France's main business is airlines, but on the side it was doing the IT and selling this to other airlines. Oracle on its side does IT services, that's its main business. And it does it across a range of industries, including air transport. And it's faced with stiff competition from IBM in particular. So the idea is for them to come together and join forces to come up with better IT, better reservation systems for the air transport system sector. So the joint venture is going to have its own dedicated management team. The two parents will grant IP licenses to the joint venture. And the joint venture will rely on the parents for some corporate functions, such as human resources, office space, probably legal, other things like that, okay? And the joint venture, the idea is the joint venture, in the long run is going to sell what it develops to third parties, okay? So initially, of course, Air France would be a major customer, but the idea is really that they develop software they can sell to third parties, all right? So let me ask you, and again, this is not just for the poor. There are three people in this room with me. So I hope that those of you dialing in will also jump in, okay? But the first question is from a I want to say from a competition law standpoint, but maybe more, the competition law aspect kind of syncs with the business aspect of what are the advantages of doing this joint venture? If you're trying to justify this from both a business standpoint and a competition law standpoint, and someone say, why is this good for competition? So what are the things about this that make it a good thing? Okay, so it could result in efficiencies in that they don't have to each do this. They can combine and be more efficient in developing the software, in that they take Air France's expertise in air transport and take Oracle's expertise in IT, and it's more efficient to come up with a product. What else? Those of you online, wake up. But here, here you cooperate with a competitor, which actually is probably a bad thing, right? From a competition law standpoint. Yeah, but why is it good here? Exactly. So efficiencies is one main reason for JV. Probably even more basic one would be what you just said, is that together you can make something that neither of you can make alone. And so here the idea is that they come up with this super software that's better than Air France or Oracle could develop alone, okay? So each of them can leverage off the expertise of the other, okay? But as you suggest, because, they're not, let's talk about this. It's an airline and software. So how is it they're competitors? What's the market they're competitors on? Right, which actually Air France is already doing, is selling it to probably not Lufthansa, but but probably smaller airlines. Yeah. And so there, there's an airline, Air France, Oracle, IT services, but where they're overlapping is right now. Right now they're competing because, as I said in the very beginning, Air France is selling its software while it's using mainly itself. It's also selling it to third parties, other airlines, for instance. So is Oracle. Oracle has air transport specific IT. It also is selling to third parties. So in that sense, they're competitors in software for air transport, right? And so there is a competitive relationship between them, but it's kind of, for both of them, this is kind of marginal. And now they're coming together to develop something that's really good software, better than either one of them could do it alone. There's something similar to this, okay? What's another reason that you would have this joint venture? It's more efficient, they come up with a better product. Anything else? Okay, it would also, often these joint ventures may not be this one because there's maybe not that much investment, but it allows them to share the investment risk, financially, because they're sharing the financial burden. So that's another justification. But those are the main reasons for doing this. Now, there are other reasons that you can have for having a joint venture that I've listed here. And again, you're going to get this deck later, so you don't have to sit there and scribble down everything on this slide. But it could be a way for one of the companies to get into a new area where the other one's an expert. So, they may come together as one of them. The aim of it is to learn more about a sector they don't know about. That can sometimes be the driver. But, the things we've talked about are the main reasons you would do this, okay? Because there's several strong business drivers. From a competition standpoint, it cuts both ways, all right? So what would be and I should say that the advantage of this from a competition standpoint is you potentially get a better product, which is good from a competition law standpoint of you get innovation on the market. And that's one of the positive things you want to show to a competition regulator is your joint venture brings new products to the market. It can also mean, and this is another justification that's very strong in a lot of cases, is you bring a stronger competitor to the market than would be the case if you didn't have the joint venture, okay? So suppose you have a market, in our market, you've got IBM that's kind of the huge player, and you have Oracle that's maybe not doing so great. And this allows, in a way, a better competitor to IBM on this market, okay? Or it could make Air France a better competitor to Lufthansa, its big giant competitor on the European market. So, it's another justification is it injects more competition into particularly an oligopolistic market where you have very few competitors. What are the downsides from a competition law standpoint of a joint venture? You guys online are really, I'm going to take names in a minute. These poor guys.
I guess if I may, do you hear me?
Yeah, we can hear you.
I guess there's a risk of sharing of information because somehow Air France is going to be a client of Oracle in the business of computer programs for airline companies, and Air France also has got competitors in the airline sectors that are going to buy the product. So Air France would be able to give information to Oracle about the needs and would also obtain information about its competitors from Oracle.
Yeah, I mean, there's one issue. I think this is what one issue you can have with a joint venture is it creates an opportunity to exchange information within the joint venture, and that can be problematic. I mean, it could be problematic here, for instance, if Oracle were giving Air France a lot of information about other clients in the air transport sector, such as if Oracle were doing work for Lufthansa. So, that would be a problem. And you would need to create a Chinese wall that would prevent the Oracle employees who are dealing with the Air France joint venture from talking to the Oracle employees who are dealing with Lufthansa. You could also have, I guess, conceptually, you could have Air France, although in our fact pattern, it's not really the case. You could, if Air France were working with IBM or other Oracle competitors, you could have the same problem going the other way. So that's one issue that you have to deal with, and we'll talk about this more in a minute, about this issue of information exchange between the partners to a joint venture and how you deal with it. Okay. Another problem is, as we said in our fact situation, the two companies are competing, okay, in the sense they both sell to third parties, and that competition will disappear as a result of the joint venture. Okay. But as we said, there's some pro-competitive aspects to this that would probably outweigh the loss of what I would view as fairly marginal competition, okay, on that market for IP or software for air transport. Another issue is you have to think about when you're doing a joint venture is what effect would that have on third parties who are not in the joint venture. So for instance, suppose that Oracle and IBM were the only players on the software market. If Air France locks up Oracle in a joint venture with a clause in the joint venture agreement that says you may not do a similar joint venture with anyone else, that could be a problem because it forecloses other airlines from using Oracle, and they can only use IBM. So if you've only got a few companies in an industry, you have to think about where does that leave the others who aren't a party to the joint venture? Do they have other possibilities, do their own joint venture with other partners? Are there other possible partners out there, or are they so big that it doesn't matter? They don't need another partner because they're so big. But you have to think about to what extent the joint venture might foreclose third parties. So I've just listed these things here, what we've just been through. Now, as I said in the beginning, you have to explain this to your client of why is it that you even care about competition law, why should they come to you, okay? And as I said earlier, it can affect the structure of the deal. If they do this and they don't consult you in legal, one issue is that some of the key provisions in the joint venture agreement may not be enforceable, because my experience is that the critical business terms in a joint venture, in a distribution agreement, in a license agreement, pick your agreement, the critical business terms are often the very terms that cause competition law problems. So one reason you do a competition review of agreements is to ensure that the key provisions are enforceable. Okay, so that's another reason. In this area, fines are unlikely. You don't. This isn't a cartel. Unless it's a disguised cartel, and a joint venture is really nothing more than the cartel. Then you could have fines, but that's rarely the case. So if you really have a true joint venture where the parties think they're going to do something better than they could do alone, it's unlikely you're going to have fines, okay? So the main reasons are you want to get in early because of the impact of the structure of the deal, and because you want to make sure that the joint venture agreement is enforceable. To take an example of a term in a joint venture agreement you want to make sure is enforceable is a non-compete. You want to make sure your partner can't go off and do a similar joint venture with your worst competitor. So you want to make sure that non-compete is enforceable. Any questions up to now? Okay. One issue you have to think about early in the process is whether or not your joint venture is, you have to notify it. Now, you haven't had the module on merger control yet, right? But so, and you'll probably cover this issue in more detail when you get to that module. But I do want to go over this at a high level right now to get it on your radar screen, because this should be on your checklist. If you're an in-house lawyer, you know, you're managing this process, okay? Or if you're an external counsel, you have to work with the in-house lawyer to manage the whole process of drafting and structuring the joint venture agreement and eventually implementing it. And one of the things on your checklist is first check to see if we can do the joint venture. And we're going to talk about that later. That's one issue. Can we even do the joint venture? The next question is, if we can do it, do we need to go get approval from somebody? Okay, because joint ventures are very similar to mergers in the sense that you can have, often joint ventures, as you can imagine, are between companies in the same industry, okay? And they come together to do something, you know, in a joint venture, and that can cause the same kinds of problems as a merger. That is, you know, where they were competing before the joint venture, now they're not competing. Well, does that have a bad effect on the market? Same issue with a merger. So the question is, that you're asking yourself is the joint venture like a merger so that it should be reviewed under the rules applicable to mergers, the EU merger regulation or the national merger regulation, okay? And this, sometimes companies forget to ask this question because it's a joint venture, it's not a merger, so they don't think about this. But you could have a joint venture that actually is treated as a merger, and you have to make a notification just like a merger, okay? And there's several, at the EU level at least, there's several criteria that must be met before you have to notify this or file it with the commission. One is that the two parents must have joint control over the joint venture. So if only one of the parents has control, it's not a merger, okay? And you don't have to worry about it. It has to meet the notification thresholds, which are typically revenue thresholds. They can be market share threshold of what is the combined turnover of the companies, and does it exceed the threshold? If it doesn't exceed the EU threshold, it may exceed a national threshold, so you have to go get approval from the National Competition Authority or several national competition authorities. And by the way, for those of you who are not in the EU, in whatever jurisdiction you're in, whether it's in Latin America or Asia or wherever, the same type of analysis applies, okay? And then this third one is the issue you actually have to spend the most time on with a joint venture, because the first two are pretty simple. You either have joint control or you don't. You even meet the thresholds where you don't. The more difficult question is it a quote unquote full function joint venture, okay? Is it and by that, I mean, is it a joint venture where the joint venture operates on a standalone basis, okay? And I'll get back to that in a minute. If you don't notify a joint venture, and you should have, you can get fined. And you can the antitrust, the competition regulator can also make you undo the joint venture later. So it's really catastrophic if you fail to notify, you should have. All right, so this is why you got to make sure this is on your checklist. Outside counsel can usually tell you fairly quickly, at least whether you tick the threshold, because they have these charts that say all the thresholds everywhere in the world. And so you can go to most law firms that do this kind of thing, and within an hour or two, they can tell you whether you got to notify, or at least whether you meet the thresholds in different jurisdictions. A more difficult question, and we'll talk about in a second, is full function. Is it full function? And as I said, it's important. Even if you don't have to notify at the EU level, you should think about, are there national, what countries is this joint venture operating in, and do we need to notify it at the national level? Okay. And again, even if you're outside the EU, the same system basically applies. Okay. So this is the full function issue, and it can be very tricky issue. Yeah. Yeah, I mean, that's a good question. That's a very good question. Question is, what is joint control? And yeah, I indicate it's very easy. It's actually not so easy, because typically you would have a shareholders agreement, and even if one party says has 51% and the other has 49, you still could have joint control if the contractual rights given to the minority partner actually require the minority partner, for instance, to sign off on the annual business plan, to take an example. That would probably be joint control. So you actually have to go look more carefully as what's in the shareholders agreement, and does that amount to joint control? There's actually, and I'll put this in another slide, there's actually a notice that the commission has put out. It goes into some detail about what kinds of things in a shareholders agreement, for instance, would amount to joint control. And there's case, you can imagine, there's over the last 30 years, there's been case law on this. The same thing at the national level about what is joint control. So it can be a tricky issue, okay, depending on what it's like. Full function. So this can be also a very tricky issue. It's not always obvious. And I should say, from a practical standpoint, I mean, my own experience is that I've been involved in joint ventures where it was really on the borderline whether it was full function or not. And so we actually would go, and I remember one joint venture was not an EU level joint venture. It was something that it was below the EU threshold. So it might have been notified different member states because it was over threshold in certain member states, but we didn't know it was full function or not. So we had to go talk to each member state authority, each competition authority, and kind of get, even on an informal basis, of say, this is what our joint venture looks like. Do you think it's full function? And so you have this dialogue with the competition authority about whether or not you need to notify the joint venture. I mean, you can also discuss whether a dialogue like that is useful, because it may not be on the record. Okay, so you always have to be careful about having that kind of dialogue, because it may give you some comfort, but not total comfort, because 10 years down the road, they may say, oh yeah, you had a phone conversation. Sorry, we changed our mind. But okay, but you look at whether or not it's a standalone business, whether or not the JV has its own management, okay, or whether the management is totally with the parents, whether it has its own resources, and whether it's dealing with, it fulfills all the activities of a normal company and not just a very specific activity for its parents. And basically the rules say, and the case law says, it's not full function if, after say a startup period of about 3 years, is still selling most of its output to the parents. So in our case, after 3 years, the JV is still selling most of its software to Air France. And it depends heavily on the parents for supplies. So in our case, for personnel, for the software experts, for IT, et cetera, okay? What do you think if you apply this back to, if you go back to our joint venture, is this full function or not? You know, so you've got JV has its own management team that kind of goes toward full function. The parents will grant licenses of technology. That may not be a problem, but you probably want to go look at the licenses and make sure they're for a fairly long duration. Okay. The JV will rely on the parents for some corporate functions. That may be okay as well, but you would want to see, you know, about, are employees seconded to the joint venture for how long? You know, what happens over, what does it look like over the longer run? Okay, can it operate independently from the parents? And then, you know, will the JV sell to third parties? Yes, in our case. Air France will be a major customer initially, but the idea is to start selling to third parties. So after a few years, Air France won't be the main customer. But, you know, it's not, based on this, I think you can make a pretty good argument. It's full function, but it's not clear, you know. And you'd have to drill down into this issue. Can only be resolved with specific facts. You'd have to look at the service agreements. You'd have to look and see what this looks like long term. Okay.
Every year or?
Well, I don't, yeah, it's a good question. So the question is, because I'm not sure if you guys online can hear this, question is, you know, if one of the parents, and which would typically be the case in a joint venture, one of the parents can get out of the joint venture by selling its shares to the, you know, selling its shares to the other party. Typically, they would have to offer them to the other party. If the other party doesn't want them, they could possibly sell them to third parties. Okay. So the question is, well, does that affect the full function nature of the joint venture? And my reaction would be no, because it doesn't really affect, it affects what's going on up here at the parent level, but doesn't necessarily affect whether the joint venture is carrying on for a long period or not. It affects the ownership, but presumably it wouldn't affect the joint venture itself. But if it did, then you might have to think about, if it did have some kind of effect on the joint venture and the longevity of the joint venture, then you might have to then think about that. And that's fine. But I think the rules basically aim at 3 years. It's not a hard and fast rule, but that's what the guidelines say is 3 years. So that's kind of the, but you know, obviously this isn't black and white. You can imagine in a business context, it's not black and white, but if it were set up in a way that you wouldn't see any prospect of the joint venture becoming independent, then that's obviously a problem. That's probably okay. Yeah. Yeah. And this just, I'm just citing this for you to have for your own, you know, have it for yourselves, is this jurisdictional analysis notice, this consolidated jurisdictional notice discusses this in more detail. There's an interesting case a few years ago dealing with whether you have to notify a change of control over a non-full functioning joint venture. So that case talks about some of these issues. And then, you know, kind of obvious that if you decide the joint venture is not full function when they first enter into it, but then later the parents give a lot of assets to the joint venture, obviously you have to think about that. Does that suddenly make the joint venture full function? You have to go get a notification, okay? And by the same token, if you think about this, suppose you had a joint venture where you decided one of the parents had control but then later the other one buys shares, exercises rights, and gets more control. The minority then becomes an equal partner or even a majority. You may have to notify that, okay? Just like you would in a merger situation if it were independent companies and that happened. So, you know, basically every time you see a client buying shares in another company that could change control of that company, red flags should go up. And you should think about, do I need to go get approval for this? Okay. Any other questions before we move on from this topic? Yes. A contractual joint venture and equity? Yeah, certainly. I think with equity, it's probably easier to see control because of the shares. Although, as we said earlier, even if a 51-49 is not necessarily control, even though a shareholder with 51% at the end of the day can take most decisions. But if the JV agreement, the shareholders agreement is structured in a way it makes it very hard for it to do that, it's got to go through all these layers, then you can imagine that it might be joint control. Whereas a contractual joint venture, and I should also say that if you have a structured joint venture with each parent holding shares, it's more likely to be viewed probably as a independent joint venture needs to be notified than if it's purely contractual, because you have an entity there that, you know, makes it more independent than if it's purely contractual. It also affects when you get into the issue of does the joint venture distributing the product jointly. Sometimes you may avoid some of the competition issues if it's a single entity. So it can affect the competition analysis go downstream as you move forward with the joint venture. So it does affect the analysis, bottom line. It can affect it in different ways. It can affect the initial analysis, but can also affect what goes on, the competition law risk that certain activities of the joint venture may run, okay? So we'll talk about later. If you have a joint venture between two companies that are competitors, it's less problematic from a competition law standpoint if they produce something together, but they distributed it on the market separately because they're obviously competing on the market, as opposed to where they jointly sell the joint venture's product, where then you are moving somebody from the market, okay? And the answer to whether that's okay or not may depend on whether there's a separate entity, the joint venture, or not. So that's a good question. It is something to bear in mind. Okay, you talked about, and I'm hoping that this does not sound new to you, about block exemption regulations. But I just want to make sure that you understand how these work, because my experience is a lot of students just, they miss this. They see the block exemption, they know all the details of the block exemption, but they don't understand the overall legal framework in which the block exemption works. I teach in another class, and I recently gave the students a distribution agreement they had to analyze under the block exemption. And I'd say 50% of students completely missed it, in the sense that they were so focused on the block exemption and they forgot that even if you're outside the block exemption, you have to worry about certain things in the block exemption, the other things you don't have to worry about. So you have to understand how this works, fits in the overall framework. So the block exemption is a safe harbor, and that's all it is. It says that if you're in the block exemption, that you're okay and your legal risk is very low. And to be in the block exemption, and hopefully you've heard this many times already, you have to be below the market share threshold in the block exemption, and you cannot have any of the hardcore restrictions listed in the block exemption, okay? If you're below the market share, you don't have hardcore restrictions, you're in the block exemption and your legal risk is low. If you're outside the block exemption, that is, for instance, if you're over the market share threshold, it doesn't necessarily mean you've got a problem. It just means you have to look more closely at the agreement, and you have to use the guidelines in analyzing your agreement, okay? So don't get fixated on getting within the block exemption or not. And you know, this is an area where my experience is clients often think they're, you know, clients in the IT sector who do lots of licenses. Some of these lawyers know the licensing block exemption better than I do. Okay, it's fairly low threshold, but okay. And they know all the rules in the technology transfer block exemption, and they know the guidelines by heart. But where they mess up is they spend all their time getting everything exactly like the block exemption, and it may not be what they should be doing from a business standpoint. They should maybe not, you know, worry so much about that and do something slightly different, but they think they have to be within the block exemption because it's this list of rules staring them in the face, and they think that everything should be like the block exemption, and that's wrong. So to emphasize, you know, the block exemption gives you more legal certainty, but if you're outside of it, it doesn't mean there's anything wrong with your contract. You have to look more closely. Now, I guess the caveat to that is whether you're in the block exemption or outside, you should not have hardcore restrictions in your agreement. So in these block exemptions, the ones we're talking about here, the R&D, and you talked last week about specialization, you have a short list of hardcore restrictions. You should not have those in because you can't qualify for the block exemption if you have them. And if you're outside, if you're over the market share threshold, if you have them in your agreement, it's likely they're certain they're caught by 101.1 and very unlikely they'd be eligible for individual exemption under 101.3. Okay, so basically what I'm saying is the market share threshold, if you're 35, if say the threshold 25%, if your market share is at 30%, I wouldn't worry about it as long as you don't have any hardcore restrictions. If your market share is high enough that you might be dominant, then you have to think about, well, I may have a problem, okay? So you're talking about joint ventures. If one of the parties is dominant, that joint venture could be problematic, which makes sense. It makes sense if, you know, Google or to do a joint venture with the other big search engine. Well, I don't think there is another big search engine. But if there were another search engine out there, obviously a joint venture between Google and that search engine would be problematic because Google is so big, right? So that's why the market, you know, if you're dominant, doing a joint venture could be problematic. But if you're not, you shouldn't worry about it so much. Any questions on that? That's kind of a basic point in competition law that hopefully you heard the first module that you did, and this is nothing new. So this just shows you the kind of agreement and the relevant legislation guidelines that apply to that kind of agreement, okay? You know, we're talking about mainly, you know, here, today we're talking a lot about R&D agreements. You can have production agreements, which you talked about last week, where specialization block exemption applies. And you can have distribution agreements where you have a whole separate module and you have a different block exemption guidelines. Now, as we talk about, you can imagine that in the business world, and sometimes I find that the commission officials drafting these things don't really get it. In the business world, actually, you don't see agreements in these neat categories. So you don't see agreements that says R&D agreement on the top or production agreement or whatever. Often in the business world, these agreements cut across several of these areas, okay? So you typically, you can have an R&D agreement. It's called an R&D agreement, but actually, take the example of developing a drug that we'll talk about more in detail later. If you're developing a drug, you come together, the two parties, you do the R&D. If you come up with a new drug, you do it, you produce it together, and you distribute it together. And the agreement deals with all of that. So then you have a question of, okay, which set of rules do I apply? And the answer to that is early in the horizontal guidelines, or the section, it explains to you which set of rules you apply when you're talking about joint ventures. When you're talking about joint ventures, they're dealing with different areas of the business process. So you ask yourself, what is the center of gravity? And you can imagine this is not always going to be a black and white answer, okay? But they give you some guidance. So they say, okay, the guidelines say, ask yourself, what's the starting point of the agreement? And what's the degree of the integration of the different functions that are being combined? So if the parties combine R&D and production, R&D is a starting point, so you probably apply the R&D rules. And actually, when you look at the R&D rules, you'll see that they would contemplate an agreement where you have production and even distribution. But if the agreement were more on production and not so much on R&D, then you would probably use a specialization block exemption rather than the R&D block exemption. And I should say, it probably doesn't make, these different block exemptions and guidelines aren't perfectly lined up, so there's some differences, but it probably doesn't matter that much which one you use. If you make a mistake on this, it's not the end of the world. This is not telling you anything you don't know already. The horizontal guidelines basically analyze different kinds of joint ventures under Article 101.1 and 101.3. So the guidelines are there. First, they explain the different hardcore restrictions. So they're helpful in understanding the block exemption. So anytime you have a joint venture agreement, the first thing you should do is go look at the guidelines. Don't look at the block exemption first, look at the guidelines. You decide what section of the guidelines you should be reading. So you should read the first general part of the guidelines and then read the section that seems to apply to your joint venture, okay? And then you might need to go look at the block exemption. The guidelines are very useful in understanding because they have a section that explains the hardcore restrictions in the block exemption, and then a section that analyzes different kinds of joint venture under general principles 101.1, 101.3, okay? So this looks very abstract here, but if you actually have a joint venture agreement, you're looking at the section of the horizontal guidelines that says, for instance, R&D agreements. And it will explain to you what makes an R&D agreement fall under 101.1 and what kinds of things would qualify for exemption under 101.3. So it fleshes out what I've kind of outlined here on this slide. The guidelines also talk about this very fundamental question that you asked in the beginning. So just step back a minute, go up to 30,000 feet or whatever. Think about generally, if you're a lawyer and you're looking at a joint venture from a competition standpoint, the first issue is, I've said already, is can the parties do a joint venture? And the first question, obviously, going to that is, are they competitors or not? Because if they're not competitors, it's hard to see how there'd be a competition law issue unless you're foreclosing somebody, a third party. But generally, it's going to be much less of a competition law problem if they're not competitors. And they can be competitors in two ways. They could be actual competitors. So right now they're competitors. And as we said in our example, Air France and Oracle are actual competitors because they're right now, they're selling air transport IT to third parties, okay? But if they weren't doing that, then you would ask yourself, are they potential competitors? Okay, so suppose in our example that Air France were not selling to third parties, we're only using the Air France IT for Air France. Well, Air France could become a potential competitor to Oracle because it might decide to start selling to third parties, but you have to ask yourself, you know, if the prices of our product, in our case, software for air transport, if that became much more expensive, would Air France enter that market? Okay, and how long a period would it take for Air France to enter? Okay, so if Air France is producing a product right now, so it probably wouldn't be difficult for Air France to enter the market, but you'd have to look at that. You know, how difficult would it be for Air France to adapt its IT, its software, so it would be able to sell it to another airline? Here's a list of questions that you could ask yourself about whether or not the parties are potential competitors. So you would ask yourself, you know, is the investment, does it exceed the financial capacity of each party? That would be a relevant question. Does each party have the necessary know-how, technical capability? Are they familiar with the process technology? Do they have the ability to sell the product if they come up with a product? And could each party bear the technical and financial risk on their own? So this is the list of the kinds of questions you would see if they're potential competitors. This is something you know already. I'm not going to spend any time on it. It just tells you what 101 says. And again, you look at the guidelines to see how 101 applies in the specific context of a specific kind of joint venture, because there are different sections of the horizontal guidelines dealing with different kinds of joint ventures. You have R&D, production, joint commercialization. So you would go look at the relevant section in doing your 101.1 analysis. Same thing with 101.3. So all I'm doing here is just listing what you already know is in 101.3, and I'm not going to spend time on it. So this is something we've touched on already that's very important. I've been dealing with a client for the last 6 months where, let me see. Okay, I just looking at. I've been dealing with a joint venture the last 6 months where what we've been doing, parties already have negotiated a joint venture agreement, and what we're negotiating now are the provisions dealing with information exchange between the parties. And we've got 2 law firms in the United States and 2 law firms in Europe and law firms all over the world just on this one issue in a joint venture. Okay, it's very tricky. The reason is, and this is typical, is the 2 parties are in the same industry. Okay, they're pharma companies. They're coming together to do a joint venture. They're competitors outside of the joint venture, and the joint venture is to make a new product. But they've got to be very careful that the joint venture is not a conduit for information exchange on things going on outside the joint venture where they're competitors. Because if it is a conduit, then they could suddenly find themselves in a cartel case, okay, where you got 2 competitors exchanging information on prices, on markets, on other things. So you have to ask yourself, you know, is there a problem with information exchange? And you know, the kinds of information you're talking about, and you could spend an entire lecture on this, of what is commercially sensitive information. Well, the quick answer to that is information that from a common sense standpoint, your business would not want to share with a competitor. That's commercially sensitive, and that information should not be shared concerning things outside the joint venture. And that can include, for instance, suppose, and this often comes up in practice, suppose one of the parties has a pipeline product that might compete with the product of the joint venture. And in the drug industry, a pipeline product could be 10 years away. It could be quite a ways away. So they're doing a joint venture right now for a product, but one of the parties hopes to have its own product on the market in the future. So you need to make sure that you're not exchanging information regarding that pipeline product with the joint venture. So how do you deal with this problem of information exchange? Is basically you have to put into place agreements with the employees dealing with the joint venture to wall them off from the other employees who are not dealing with the joint venture, okay? So make sure there's not, so you have Chinese walls within a company typically to prevent the information from flowing across, okay? And then you also have guidelines that the parties have negotiated to say how they're going to do this, okay? Any questions on information exchange? All right. De minimis agreements, this applies to all kinds of agreements, not just joint ventures. If you're looking at an agreement, one thing you should ask yourself is whether it's de minimis, and there's a specific notice on de minimis that tells you what conditions there are. So you have to be below certain market share thresholds, and you can't have certain hardcore restrictions. But this is something else that you should put on your list of things to look at in dealing with these agreements, because it may mean that if you're a small company, don't have a big market share, you may not have to worry about this at all. So this is kind of a basic list of questions you should ask yourself. Are the parties competitors? Does the agreement have hardcore restrictions? Are there other things that could be problematic in the agreement? What are the pro-competitive justifications for the agreement? What efficiencies? And will the agreement benefit consumers or customers? I think this is a good place to take a break. It's a little early, but let's go ahead and take a break now for 10 minutes and we'll come back. Okay? Yeah, okay. I've got two questions, right? No, that's just one. That's just a one. It's the same. It's just one. Yeah. Okay, yeah, it's good. Okay. We were having a debate whether to make all of you turn on your cameras. So those of you who are cooking or surfing the internet or doing other things we won't talk about, we can see you. See, I know that more than half of you aren't even there because I say that and you're still not up. And the second thing we're going to talk about, we were talking about is, should I randomly call on you to check that you're listening and that you're there? So be careful. It's still not there. We see who's not here, huh? Huh? Let's see. Felix, Vicky, yeah, Danielle, and then me. Huh? Okay. You see, you got, where are you, out in the rain? Now I understand why you turn the camera off. Okay. Okay, we'll start. And we'll check back with Katerina later, see if she's actually there. Okay. How about Hatis?
I am there.
Okay, we're just checking. Okay, we got a question. It's a good question. I hope all of you can see it. So the question is, first question is, we've talked about these different instruments, the horizontal guidelines, the block exemption regulation, the de minimis notice. And the question is, well, you know, great, in what order do I look at these? And I think you would first apply the de minimis notice, because if you're below those thresholds, then you don't have to worry about anything else, okay? So first you ask yourself, do I qualify under the de minimis notice, okay? And then as far as the horizontal guidelines and the block exemption, as I said, you'd first look at the horizontal guidelines because that's the broader set of rules. And then you would look at the block exemption, okay? So, I mean, when I'm looking at an agreement, I'll first go read the relevant, maybe several sections of the horizontal guidelines, sort of the introduction, where they set out general principles, and then look at the specifics on a specific kind of agreement. And then I might go look at the block exemption, okay? But you first look at the horizontal guidelines to give yourself a broader view of the agreement. And then you would check to see whether you could qualify for the safe harbor under the block exemption. Okay, the second question is, okay, suppose that I have a joint venture that is a full function joint venture that I've got to notify. Can I then forget about worrying about the horizontal guidelines and the block exemption? I think the answer to that is no. That is, generally you're going to have to comply with the horizontal guidelines and the block. You don't necessarily have to be within the block exemption, but you have to avoid having hardcore restrictions, okay, whether you notify it or not. Now, there may be some things in there in your agreement that could be problematic from a competition law standpoint. It may even be a hardcore restriction. And so you may ask the competition authority what they think about a specific provision in the agreement, saying, we think this, you know, we understand that this could be very problematic, but we think in this particular case, we have arguments to justify it. And so could you allow us to have this? And one advantage of, I mean, you know, as a general rule, as a lawyer, you do not want to get in front of an agency, because when you ask the government a question, you always get the, exaggerate a little bit, but you often get the wrong answer. So, you know, as a general principle, you don't want to get in front of a competition law agency if you can avoid it. But the exception to that is if you're in a case where you have a big joint venture, it's a lot of capital investment by the parties, you may want the extra comfort you could get by talking to an agency. Now, if you don't have a joint venture that qualifies as a merger where you would have to go to the agency, it may be hard to get the agency to give you any meaningful feedback, although you could contact them at least on an informal basis. But if you're notifying somebody as a merger, the downside of that is you've got to get their approval. But the good side of it is once you get that approval, it's kind of like a stamp that says lowers the legal risk significantly of any problems in the future, because the agency has looked at your joint venture agreement and said it's okay. But to go back to this question, you're probably going to have to follow the, you know, the rules, and that is not have hardcore restrictions unless you convince the agency that you've got a hardcore restriction, but you've got good arguments in favor of doing something. And so the agency gives you a special individual exemption and it's not a problem. Any questions on that? Okay. Charlotte, are you there? There she is. All right. R&D, we're going to now talk about R&D collaborations. And this slide just shows you all the different, you know, sets of rules at the EU level that could conceivably apply to a joint venture, you know, in the joint venture, okay? And we've talked about some of them today, but, you know, if you have a license in your joint venture, it's conceivable that the technology transfer block exemption and the guidelines might apply. But we've talked about all these other things already. But there are a number of different, you know, sets of rules that you've got to worry about, which makes this area so complicated. So R&D agreements can take lots of different forms. I mean, you can have, you know, you can have the parties create a joint team, or you can have the parties jointly entrust it to a third party like a university, or you can have the parties each do some specific function and specialize in it. You can have one of the parties contributes money and the other does the work, okay? And you can have things where they do the R&D, they come up with a new product, they produce the new product, and they jointly sell the product, or in this case, it's called commercialize the product. So you have joint exploitation of, that is production and distribution by the joint venture. So there are all kinds of R&D agreements that can be just R&D, or they can be everything. They can be hybrid agreements. And as we, as we already talked about, one of the first questions you would ask is, are the parties competitors? Because if the parties are not competitors, the cooperation is generally unproblematic. And let me stop here. Let me go back a minute. I forgot to say something earlier. This is a basic principle, okay, that remember, and even if you're not a competition lawyer, this is a good thing to remember. Closer you get to the market, the more your competition law risk goes up, okay? And the reason that can be important is, a client might call you 11 o'clock at night and say, we're going to sign an agreement tomorrow morning. Do you think we have a competition law problem? And if it's an R&D agreement, it's only R&D, it doesn't have production, it doesn't have distribution, it's pretty likely that the competition law risk is low. And it's useful to have that idea in your head when you're looking at these agreements, because if you have in your head that R&D agreement is, the risk is low, then it's going to affect how you advise a client. Because competition law, the other general principle I tell you is competition law is rarely, if ever, black and white. Okay, it's almost always gray. So when I'm advising clients, it's not yes, no, this is the risk spectrum. And if you do this, you're going to be in a low risk scenario. If you just do this, you're going to be in a high risk scenario. And you may give a client different options. Say, if you do this, it's low risk. Do this, it's high risk. And they have to look at that, and you have to have a dialogue with the client on how does the risk match up with their business objectives. So they may be willing to take a high legal risk because the business objectives are so critical that they're willing to run a risk. But that's the dynamic of competition law advice, is thinking about the risk. And and that's why this is important, because if you're advising on a pure R&D agreement, the risk is never going to, almost never going to be really high. It may in rare occasions, but generally going to be low. If you keep that in mind, then it's rare that you're going to tell a client, you cannot do this. What you can say to the client is, you can do this, there's some risk, but since you're in an R&D scenario, your risk is not super high in any event. So it's good to keep this idea, whereas if you get down to distribution, that you're jointly selling on the market, you're setting prices together as joint venture partners on the market, your risk is going to be greater because you're more directly affecting the market and the competition on the market, okay? So in that scenario, if two companies are jointly distributing something, you're going to look more closely at it because the competition risk is going to be higher. So your red flags are going to be going up in your mind as a competition lawyer. You're going to look at this much more carefully. And I think it's useful to have this general picture in the back of your mind, because the problem in this area, particularly R&D agreements, because the rules are so specific. Same thing with licensing agreements, distribution agreements. You have block exemptions and long guidelines with all these rules. You easily can get lost in the trees and not see the forest. And it's really important that you see the forest in terms of risk assessment, because that's what you're doing, okay? That's why as competition lawyers, we don't really have to worry about, we have malpractice insurance, but we don't have to have the kind of malpractice insurance that tax lawyers have. Because tax lawyers, it's either yes or no more often, okay? Want to make sure a tax lawyer has whereas competition lawyers is rare, it's going to be malpractice, okay? Because there's never a clear answer. Any comments or questions on that? Vicky? And then me? Any question? Okay. So, are the parties competitors? As we said, this is a fundamental initial question. As I said, I got the basic idea, R&D is generally unproblematic. So you know, if you out-license R&D to a university, it's unlikely to raise problems, okay? Because you're just giving know-how to the university and say, could you do research? But to answer this question, you know, are you a competitor? Your first question is, what is the market you're talking about? So when we were talking about our Air France Oracle, and we were talking about whether they're competitors, you have the first question is, as we talked about, is what market are you talking about? You're not talking about airline market. You're not talking about the software market. You're talking about the market software for airlines. And in our example, that's the relevant market. And as we said, in that relevant market, we first have to say that's the relevant market. Once we do that, then we ask, are they in that market? And the answer was yes. They're both selling in that market right now, okay? So that's the same thing you do here is you first have to define the market. But what's the tricky thing here, and the important thing to bear in mind when you're talking about R&D agreement is you're not just talking about product markets, you're also talking about technology markets, okay? Because there are two ways that an R&D joint venture can affect competition. One is that competitors on the market for products or services are coming together, and that may affect competition on that market on the sale of that service product. But also it might affect the technology in the market. And in the recent years, it's this technology aspect that has really caught the attention of competition law enforcers because they're very keen to promote innovation. Innovation is a magic word in competition law. Commissioner Vestager probably says innovation once an hour. That's her favorite word, okay? And innovation is key aspect of competition law. And so when you're talking about joint R&D agreements, the innovation is critical. What effect does the agreement have on innovation? So you have to look at the products and you have to look at the technology. The product market is fairly easy. That's nothing really new. The technology market is, you know, what technology are they, what research activities are they conducting? The commission has come up with a way of calculating because you want to see how big are the players on the market. And you can tell that fairly easy with the product market. It's more difficult with technology market. And the commission says, oh, that's easy. You look at the licensing income they get from that technology. Well, you can imagine that's not so obvious, okay, of how much income they get from a technology, but that's not so easy. But okay, at the very least, what you'd want to know is in this area, how many companies, are there a lot of companies out there doing research in this area or not? Or are these the only two doing research? So you're taking one of them off the market by combining their research, okay? Because if that's the case, clearly you've got a problem because it's affecting innovation on the market by taking one of the main research poles off the market, okay? And you know, it depends on the industry. For instance, in pharma, which I have a lot of experience with, if you're looking at a certain market, say diabetes, and you're looking at injectable diabetes treatments, if you Google that, you can probably, there are sources out there that tell you exactly what's going on in terms of research in that narrow area because there are services out there that track this in great detail. So you could find out a lot about how many poles of research there are in diabetes for injectable diabetes products. Whereas in other industries, that may not be so easy to do. But your clients, the business people, will probably know. They will, I mean, that's their business to know. They're supposed to know their business, their markets, and who's doing what in those markets. So they'll probably have a good idea of how much research is going on in the market, okay? What most universities, okay, we have a question, couple of questions. One question is how to define technology market. Good question. I don't know. I mean, you're gonna have, you would look at the industry and ask yourself, what you would ask yourself, okay, what is the technology? What products does it relate to? But of course, you could have a technology that actually relates to a number of products. But you probably would figure out what that technology is in that given business. But it's not like a product market. I don't think you could use the SNP test to determine technology market. That is, if you raise the price of the technology, would other people enter? That doesn't make a lot of sense to me. So I think as your question suggests, this can be a tricky issue. It's obviously very industry specific and product specific. Okay. Another question is, aren't most universities active in exploitation? I think that's true. That exploitation is, in this context, we're talking about R&D, is a term of art. Exploitation doesn't mean the university is actually making and selling the product, but it may be licensing others to do it. Okay, and so there can be issues about terms in an agreement with a university that prevent, for instance, the university from out-licensing the results of the joint R&D that could raise competition issues, and you'll have to look at. So the mere fact that a university is not actually making and selling a product doesn't mean that there could not be competition issues, because the university could out-license the product, as your question suggests. I hope that answers the question. So this goes back to, what are the restrictive aspects of an R&D agreement? But as I said, the guiding principle is the antitrust, the competition law risk is fairly low. If the R&D is an early stage and not close to being marketed, unlikely you're going to have much of a competition issue. And this is very kind of general, okay, general principles. If the R&D is an entirely new product, it's unlikely to raise problems unless, it's taking a pole of research off the market. So it hurts innovation. If there's no joint exploitation, no joint production, no joint selling, less problematic. If it concerns a minor input for a final product, less problematic. Where you're more likely to have problems is if the parties have high market shares on existing markets, or if they're key centers of research for existing markets, okay? So you see a joint R&D agreement, that before you even start looking at it, the things that are going through your mind are the parties competitors for the product? Are they competitors in research, and what does the general landscape, competitive landscape look like for the products and the research? So anytime, this goes for joint ventures we're talking about today or anything else in competition law. If you are talking to a client about a competition law problem, the first question you ask is, tell me what you want to do and why. Because the answer to that will often tell you what the competition law problem is going to be, of why they want to do something. It may on its face look okay, but then they've got this bad, reason for doing it that's anti-competitive. So that's the first question, is just get the facts from the client about what kind of agreement they want to do and why. So if they tell you, we want to do a joint venture agreement with this company because they've got this great new product they've been researching, and we want to buy it up before it becomes a competitor, that could be problematic. We'll talk about that later. But think about, you've heard a lot about Facebook being attacked because it buys up startups that if they allow the startup to develop, the startup will become a competitor. WhatsApp, Instagram. So that's what we're talking about is, it looks okay, joint venture, but if the intent is actually what they're doing is taking a potential competitor off the market, that could be problematic. So that's the first question. Second question is, tell me about the market. Tell me, what does this market look like? How many competitors are there out there, both for the products and tell me about the research in the market. How many companies are doing research in this area where we're going to team up and do a joint venture? Tell me, client, about this market, because you can never, we're going to get in all kinds of detailed rules in the block exemption and the guidelines, but you cannot jump into those rules. You first have to think about what the broader picture of what does the competition look like, because you have to apply you can't apply these rules in a vacuum. You have to apply them in the context of the market. That's the basic, it's the basic thing as a competition lawyer. If you start blindly applying these rules, which many people tend to do, it's not going to be a good answer. So, you have to think about what does the market context look like, and then, as we said, so that's going to affect before you even know about the specifics of the joint venture, you're always going to have in your head kind of, is this an area, an industry where it's likely to be issues or not, depending on what the structure of the market looks like, and depending on, how much research there is going on out there. And if you know the joint venture, if you didn't find out the joint venture agreement is limited to research, that's another, early data point that's very useful, is to know that it's unlikely to be high risk. So before you even start looking at any specific provisions, you already have a lot of information that's useful to your competition law assessment. Please stop me if you have any questions. And so this is kind of just saying what we've already said, is that, if the joint venture is likely to lead to new or improved products, that's a big justification for it. But if the parties both are doing research in an area, and this is simply, they may be coming together to avoid competition from the other party, and that's, so you have to ask yourself, what's it going to do to innovation in the market? The block exemption, like all block exemptions, has a list of hardcore restrictions. And when the exam, by the way, is very likely to be something like a term sheet for some kind of joint venture agreement. And it's probably going to require you to, it's open book. So it's going to require you to go look at this stuff, because I'm not trying to download into your head all these rules, because the main thing I tell you about the hardcore restrictions is you should go read this list every time that you look at a joint venture or look at an agreement. I mean, I've been doing this a long time, and I guarantee you that I go look at it every time, and I don't trust myself. Because one thing is, I have a bad memory, but they're always changing these rules. So I may have in my head the version from 20 years ago, whereas they changed the rules 10 years ago. And so you don't want to trust your memory, but also these rules are so specific, and you have to read them so carefully, because you should do it every time. And if any of you have looked at these already, I'm sure you will agree that they are not a model of clarity. Okay, they're extremely poorly drafted. Okay, they have double negatives. It's a nightmare, and people make mistakes all the time. I've talked to the people at commission and draft this stuff. They admit, the guy who drafted most of these things, he admits that he can't understand. He drafted them. I mean, they're complicated, and there are too many double negatives, and it's complicated. Okay, and so all I can say is, before we get into these different hardcore restrictions, is read this 3 times, before you start advising a client, to make sure that you've got it right. But here are the basic principles I'll go through quickly. the joint venture agreement should not restrict the ability of the parties to do R&D in an unrelated field. So the basic principle of keep in mind is innovation. Remember innovation, okay. Anything that restricts innovation, red flags should go up. Here you're restricting innovation in a field unrelated to the joint venture, so clearly a problem. Can't do it. Restriction on parties' ability to do R&D once you get into commercialization. So while they're doing joint R&D together, that's okay. You can prevent them from going and doing something with someone else. You want them to focus their efforts on the joint R&D. But once you get to the stage of the project where they may be jointly producing something, and they've moved beyond R&D, then either of them ought to be able to go do R&D if it wants to. Now, in my mind, this might be a good candidate for change in the future because it doesn't make a lot of business. It kind of seems very academic and esoteric for me to say to a company, well, you know, you can tell your partner not doing R&D as long as you're doing joint R&D, but then you start selling something, they can go start doing, you know, R&D on how to beat the product that's on the market. I mean, that I'm not so sure, but that's the rule right now. You generally can't limit output or sales. And as a general rule, you can't fix the selling price unless you're jointly selling, okay? We'll talk about that more later. And then any customer or territorial restrictions you need to look at carefully, okay? Because there are very specific rules on what kinds of territorial restrictions you can put on between the partners in the joint venture. You may allocate territories, but you just have to be careful. So this list is just to kind of show to you, if you've got limitations on R&D, on sales, on territory, on customers, you should go look closely at the block exemption, okay? Then, just like other block exemptions, they have something called excluded restrictions. Does anyone know the difference between a hardcore restriction and excluded restriction or softcore restriction? Okay, hardcore restriction means that the entire agreement can be struck down, okay? So you really don't want to have a hardcore restriction because it may not be just that provision that gets struck down, but the entire agreement. Whether that happens will depend on the rules at the national level on how important a particular clause is to the entire agreement, okay? But the hardcore restriction can result in the entire agreement being struck down, whereas excluded restriction is only that specific provision, okay? And here in R&D agreements, there are two kinds of excluded restrictions. One is a no challenge provision. So in the commission's view, no challenge restrictions are bad because your partner is the one most likely to be able to challenge your IP. So you don't want to prevent that party from being able to do that. And that's the same rule for licenses, is no challenge provisions are bad under EU competition law. Instead of having a no challenge provision, you can have a provision that says, if you challenge my IP, I can terminate the agreement, okay? But you can't have a no challenge agreement would not be enforceable. And then an obligation not to grant licenses to third parties to make the product unless the agreement provides for exploitation by one of the parties. So take our example, the university we were talking about before, that one of the parties is a university and the other party is a company that once you come up with something, the agreement says that that commercial party will go out and sell on the market, university doesn't. It's okay to put a restriction on the ability of the university to license the technology that you come up with your joint R&D, to license that technology to some third party. That's what this says, is that it's okay to do it in that situation where one of them is going to sell on the market, okay? But you can't do it if neither one of them is planning to sell on the market, because you want to disseminate technology to the extent possible. So it's another guiding principle. One principle is innovation. So anything that affects innovation, red flag should go up. The other general principle is good to disseminate technology. That's another pro-competitive fundamental goal of competition policy. So anything that prevents broad dissemination, you should look at carefully. And then please stop me or ask questions. I'm looking at no questions. Okay. The R&D block exemption is a bit strange because it's got a section that sets out exemption conditions for exemption. Other block exemptions don't have this. So it's you kind of be aware that early on in the block exemption, the text, you've got these conditions. And you have to just go check to make sure that they're fulfilled. One of them is that both parties generally should have access to the results of the R&D, unless one of the parties is going to be responsible for exploiting the results and the other not. You have to allow access to these are fairly detailed rules. I'm not going to spend much time on them yet, because you'll forget it tomorrow. The key is to remember to go look at these rules every time. You have to allow access to pre-existing knowledge if you need that to exploit the results. So again, the emphasis is on the ability to exploit the results of the R&D and disseminate the technology. Okay, I'm not going to go through each of these. And like the other block exemption, you have market share thresholds. If the parties aren't competitors, you don't have a problem, the block exemption applies. If you have joint R&D, the market share threshold is 25%. The duration of the exemption is for the duration of the R&D. If they jointly exploit the results of the R&D, the exemption continues for 7 years. And after that, it depends on the market share. So again, you have to go read this. I mean, there's no point in me going through each detail in this block exemption. The key is for you to understand, how it works. So you can, when you read the details, you'll understand how do you use those. Let me stop. I want to do a hypothetical before I do that, see if there are any questions. Okay. This is a hypothetical in the pharma industry, okay? Because you see a lot where you probably see the most R&D collaborations is in pharma. That's where I see the most. So in our hypothetical, we have a major Japanese company with global operations called Nippon Pharma. They're produces a leading treatment for stage 2 and 3 breast cancer that's delivered via an IV. So you go to a hospital and get an IV for this treatment, okay? That's one party. The other party is Iberica Labs, which is a medium-sized Spanish company that has operations throughout Europe. It has a lot of experience with injectable therapies, right? And it produces a cancer treatment for stage 1 breast cancer that you deliver via an injection, okay? So you wouldn't necessarily have to go to a hospital for that, I guess. And so what they're going to try to do in a joint venture is come up with a product that for stage 2 and 3 breast cancer that you deliver via an injection. All right, so you're going to take Nippon's expertise in stage 2 and 3 and marry it with Iberica's expertise in injectable therapies. Everybody with me? Because you have to, as we go through this, if you can't remember this, you're sunk. Daniel, you okay? Stop raining. Okay. And I should say, this is a presentation I often do to pharma clients. So it's something I do with the actual, clients. So I didn't just develop this for you. And so it gives you a sense of kind of from a broader perspective, what you have to think of. So this shows you, if you're a lawyer and you're having to deal with this collaboration, the different things in your timeline that you're going to have to deal with. Okay. So first off, we've already talked about this. You have to figure out whether parties compete and can you do the deal. You're going to have to think about another preliminary issue is whether you need to notify this, whether you need prior regulatory authority from regulatory approval from a competition authority. You're going to want to do due diligence on your partner to make sure there are no problems your partner has that may come back onto you. And you're going to think about this issue of information exchange, and do you need to put in some kind of protocols to deal with information exchange? You're certainly going to have to, something we haven't talked about, certainly in terms of when you're doing the negotiations of a joint venture, you're going to have agreements in place with, the employees who are negotiating the joint venture, that they, whatever information they're sharing in part of that negotiation doesn't get spread out throughout the company, because they're probably going to be exchanging and thinking about whether it makes sense to do a joint venture. Fairly competitively sensitive information that if the negotiations break off, you want to make sure that don't become, if you exchange, you might not want to exchange certain information even in those negotiations. That's something your business people should ask the legal department is, what can we talk about in our negotiations? Okay, because you may not want to be exchanging the most sensitive information like your pricing or your market strategies with your worst competitor, even though you think you may be able to do joint venture with that company for one area, okay? But even the information you do decide to exchange that may be sensitive, and you want to say, okay, we break off negotiations, only the people involved in this will know about it, and they can't go talk to people in marketing or pricing, whatever, okay? But then you have this other issue of, if we do the joint venture, do we need to put in place information exchange protocols later, okay? And I should say the information exchange protocol probably, if the ones dealing with ongoing information exchange, would probably come later in the process once you reached agreement. So the first information exchange issue is the people negotiating. Only later will you have to deal with, do we have to have ongoing agreement on what we can and can't exchange, what firewalls we might have to have in place, which is what we talked about before. Okay, then you get to negotiation, negotiate key commercial terms, and you're fine tuning those terms to deal with competition issues. So there's going to be a dialogue between the negotiation team and the competition lawyers about, this is the current version of the agreement or the term sheet. Is it okay from a competition law standpoint? Is there anything we need to change? Okay. If you had to get regulatory approval, then you're going to have that issue of clearance. If you can't implement the agreement till you get the green light from the competition authority. And then you've got the issue, okay, we've signed the agreement, but suppose you've got a pan-European agreement. You're probably going to have, to educate the local country teams on the agreement, as well as educate the local legal counsel in the company on what specific things there are in the agreement they're going to have to watch out for. Okay. And you may have to put some kind of structure in place to ensure competition law compliance, particularly if you have this information exchange issue. You have to sensitize the local teams, both the business teams and the legal teams, to potential competition issues going forward. But this is just kind of a basic, gives you an overview of a basic timeline of the deal. So the first question, can the parties do the deal? Okay, and this, we've talked about this, but let's go through this again. Do the products compete? If the answer to that is no, then not a problem. If it's yes, then you would ask, okay, what does the structure of the market look like? How many players are there out there? So, you would do this. And you would look at how many players are there in the market. Now, let me ask you this on the basis of the facts we've seen so far. Do the products compete? Maybe a better question is, what would you be asking the client? Because they're the experts, you're not, you're just a lawyer. What questions would you be asking them to figure this out based on what you see here? What do you think, Danielle?
Okay. So maybe one of the questions that I would ask to America is if they produce also treatments for stage 2 and 3 breast cancer. Also for Nippon, if they also have kind of products that would be related to deliverable via injection.
I couldn't hear him. What did he say?
Oh, can you hear me there?
Yeah.
Can you listen to me now?
I'm just deaf. It's just me.
Oh, I can write it down.
It's okay. It's okay. I mean, it's just me. That's worse. Did you hear what he said? Well, I mean, let's think about it. Okay, they're both treating cancer. So first question is, one stage 1, one stage 2 and 3. Does that compete? Okay, I don't know. You'd have to ask the companies that are expert in cancer treatments. I suspect there's some overlap, right? If you're taking the stage 1 treatment, it probably depends on the doctor what they say. Okay, you got to switch to the next phase. Okay, so but that's one question. Another question would be, to what extent, if you're getting something via IV, right, is that interchangeable with the injection? Okay, and it may, and that may depend on, you would think of IV, you got to go to a hospital probably, whereas the injection, you could probably just go to your doctor. So, does that mean that these two companies right now are competing or not? And how easy would it be for them to compete, even if they're not competing now? There's some other things. Are both treatments purchased by the same type of organization, that is hospitals versus pharmacies? And are the treatments, are they used as alternatives, or can they be used together? That you get the IV, but you also get the shot. I don't know. So, these are all the kinds of questions you would have to ask. So the bottom line is, you're trying to understand the market. As I said earlier, you must understand the market to answer these questions. So your first question is always going to be, what is the relevant market? So this is just a relevant market exercise. Okay. Is it the first one, or is it the second where they're on different markets? All right. You also want to ask, do the parties have competing R&D projects? If they don't, unlikely to be a problem. If they do, then you have to look at, see you know, what does that market for technology look like? You know, Iberica in our example has a stage 3 breast cancer way up in the pipeline. So the question is, you know, is that going to compete with Nippon's current product? Probably not, because it's way up. But if we were in phase 3, for example, then it might be competitive, and it might be doing a joint venture might be more problematic, because Iberica would be viewed as having a product on the just about to enter the market. So therefore, a joint venture like this would be much more problematic, all right, because it would be taking a potential competitor off the market. You know, you'd have to analyze the competitive landscape. And again, if it looks like the one on the left, where you've got 2 big players and they're coming together, obviously it's more of a problem than if it's a fairly competitive market and you're going to create, you have 2 go down to 2 combined, but they make that new company, the joint venture, a stronger competitor against the other players on the market, okay? So I'm just repeating what we've already talked about, is that you've got to look at the structure of the market. What is the relevant product market? And once you figure that out, you have to look at how many players on the market and how strong are they. I see. Okay. Different comments. I think they're not questions. We've already talked about this. Do they have competing R&D projects or not? Okay. And this shows you, this just reiterates what I was talking about before, these cases. There's a trend, and you see this in merger cases. These are all merger cases, but you would also see them in looking, in my view, you would apply the same analysis to a joint venture. There's been this big trend among, you know, big hot topic in competition law these days is killer acquisitions. What we were talking about before, Facebook taking WhatsApp off the market, okay? And you see it a lot in pharma. Is a big question in a pharma joint venture or merger is what effect will that have on innovation in this therapy area, okay? Is it taking a key R&D program off the market by doing this joint venture, okay? And if it is, they may, in the merger context, they require them to divest one of the research programs off to a third party, okay? So then a merger, to allow a merger to go through, you can say, okay, you can merge the 2 companies, but to make sure that we're keeping a lot of R&D, you're gonna have to divest one of the R&D poles, okay? You can imagine the same thing in a pharma alliance where they're both doing R&D and they have the 2 big programs in R&D, they're coming together to do more R&D, but to say to one of them, okay, you've got to get rid of some of your R&D to a third party to maintain the innovation in this sector. So it's a very hot topic. The problem is, and there's been a lot of debate about this, is, you know, is the competition authority overstepping its authority and sticking its nose into things like this, that it probably is not the expert on R&D in diabetes or whatever product market you're talking about. So is a competition authority really well placed to be telling the authority, telling companies what they, what they should be doing? All right. And as I said, this is Vestager and other competition authorities are very focused on this idea of avoiding killer acquisitions and protecting innovation. Big issue in pharma, but it's even bigger issue in digital. That's where most of the debate has been about these digital platforms acquiring Google, Facebook, acquiring startups to prevent those startups from becoming big competitors. Okay, but you've got that same logic applying in other industries like pharma. And the reason you've had a lot of discussion about killer acquisitions is a lot of times if a large company acquires a small one, they're not caught by these merger rules we were talking about. So they escape regulatory scrutiny. Okay. And that's given rise to a big debate of should we change the rules to allow the competition authorities to look at this kind of acquisition where you've got a large company acquiring a smaller one. So we may well see a change in the rules. Even if you don't see it at the EU level, you may see it at the national level, okay? So you should look at your different countries, you know, keep an eye, if you're doing competition law, you have to see what the authority of your country is thinking about, because this is a very hot topic right now. It can also be a problem if you have a client that's dominant and is doing a joint venture or merger with another company in the sector. Is the purpose of that to take a smaller competitor off the market? That could be abuse of dominance, okay? You've had a couple of cases here where something like that has been the theory of the case of the dominant company abusing the dominance by taking a competitor off the market. This is issue we've talked about already. Does the deal require regulatory approval? In a joint venture context, in R&D joint venture, if you have independent companies that are doing this, and this kind of goes to the question you asked earlier, if you're having a contractual joint venture, we have on the left side, it's more unlikely that you're going to need approval. On the right side, you have an independent new company that's set up, AB in our example, that's more likely to require approval, but then you have a big gray area in between these two extremes, okay? And so as we said earlier when we went through the examples of what is full function, this is not always clear.
Quick question, if I can jump in. Quick question. Yeah, I was about to ask if just in the previous slide, if it's a full function joint venture, the regulatory clearance that we're talking about is the merger control test, or is it another clearance?
What did he say? I can't. It's because up here I do.
I try to repeat to see if it's clearer. The regulatory clearance that we talk about in the independent joint venture, the full function joint venture, is that a merger control test or is that another one?
Yeah, I mean, this is looking at how you answer this question. The rules that you apply are the merger control rules. Okay, so you look at the jurisdictional notice that I put up on the screen earlier, that notice is part of the merger control rules. And you'll talk about this issue in the merger control module. You'll talk about what do you do about joint ventures, because it's a difficult question, but I'm just kind of introducing this issue to you now. But to answer this question, you don't look at the R&D block exemption or horizontal guidelines, you look at the merger control regulation and the different guidance and notices that have been issued in connection with that regulation, okay? So this is a merger control issue of do you treat the joint venture like a merger or not, okay? Now, this is not really a competition issue, it's more a corporate issue, and just to mention that you would want to do due diligence on your partner just to make sure they don't have a bunch of competition issues in their closet that could come back and hurt your client, okay? But this is really just list some, you want to check on a whole range of issues in terms of due diligence, but these are the competition law issues you might want to check. And of course, if you're just doing a R&D agreement, you may not care so much about this. If you're doing a major joint venture, it's kind of a basic joint venture affecting it's very important to the company, you may want to do this. This is about our information exchange. We've already talked about this, so I'm not going to spend much time on this. You've got competitively sensitive information. And again, we could spend a lot of time talking about what that is, but the basic answer is it's whatever common sense tells you, you do not want a competitor to see. I see that. Okay. There's a question, good question about, suppose that you have, it's similar to one we've talked about before. Suppose that you have an R&D alliance or joint venture or whatever you want to call it, that I think I understand the question. That you would have to get merger control. You tell me if I'm getting this wrong. This is.
The question would be, for example, you have a R&D agreement. The market shares are, let's say, 20%. Maybe 2 years later, you have a merger, and the market shares would, by now, increase to say 30, 40%.
So, yeah, okay. What happens if the market shares change? I think I'm not wrong in saying this, why I tell you have to look at this all the time. I think in the block exemption, there's actually a rule that tells you what to do if during the course of the R&D agreement, the market share increases. Okay, so as you remember I'm thinking that it goes for 7 years, and it will continue on for the exemption will continue past 7 years if the market share doesn't exceed 25%. I think there's also a provision in there dealing with what happens if in year 2 the market share jumps to 50% or something, over 25%. But I don't have that top of my head. You'd have to go look at that. But I think the block exemption deals with that. But that's a good question. As a practical matter, I'm not aware of any case where a competition authority, after a joint venture is put into place, has come in later and said, oh, your market share is high, you've got a problem. So to me, this is more of a theoretical issue that's dealt with in the block exemption, but in practice, almost never, if ever, comes up. So I want to go through some specific issues that you typically run across in doing one of these deals. And I'm looking at most of these from a standpoint of a business goal of one of the parties and how you deal with it. So, let's first look at, how you deal with the allocation of tasks of commercialization of the new product that you've come up with. So you say Nippon will be the sole manufacturer, and then each party will go off and distribute it in different territories. Usually that's going to be okay. All right, that's fairly typical. So you would have, typically you might have Nippon Pharma doing everywhere in Europe except Iberica, the Iberian Peninsula, and you have Iberica doing it there. Okay, so you'd have 2 different territories. It's okay to do that, as long as you don't have restrictions on sales between the 2 territories. But Nippon's thinking to itself, well, I don't really want cheap Iberica product coming into my higher price territory. I don't want my Portuguese product coming into Germany. So I want to stop that. So I can prevent Iberica from actively looking for customers in my territory, but I can't prevent Ibericum for selling to customers who come from the Nippon territory and ask for product. Okay, this is something you'll go into a lot more detail when you talk about distribution agreements, but the same principle applies here at the distribution stage about restrictions between different territories. In the pharma industry, because you've got a lot of parallel trade in pharma with big parallel traders, the fact that they can't stop passive sales means as a practical matter, there's going to be sales because the parallel traders know that they can come ask for product in this industry. So you're going to have a lot of parallel trade. Yes. Good question. So the question is, you will spend, I'm sure, an entire session on this when you get to vertical agreements, because as you suggest in your question, a big area of discussion when you're talking about this kind of restriction is what about online sales? And this is a huge topic right now because they're revising the rules on this for vertical rules on how do you deal with online sales, okay? And so this, right now, as we speak, this is changing. And I don't know where it's going to land, but generally, you know, to give you a very high level answer, and this may change, if your website is global, it's probably, you know, if you had an English website, it's probably not going to be viewed as an active sale, okay? But if Iberica puts up a website in French, it might be. Okay, so if it's aimed at another territory by language, for instance, it might be. Okay, but this is an area that's very interesting because obviously that's how products, the large number of products distributed online, you know, and so this issue is one that's a super hot issue, you know, that right now they're discussing. They haven't quite come up with their answer yet. Okay, and there's been a lot of litigation about this as well. So another issue, business. This is a business issue, right? It's not a legal issue. So Nippon's business is saying we need to make sure that Iberica's prices are not much lower than ours, so that, you know, our customers don't start asking for lower prices as well. So we need to protect our pricing. Okay, that's the business goal. But they can't do anything about this because there's a basic rule that says that a distributor, or in our case, a joint venture partner distributing in its territory, must remain free to set their prices. And if they're not free, it's called resale price maintenance, which is almost in every jurisdiction in the world is illegal. So in other words, if I'm supplying product to you, I can obviously set the price between us, we negotiate that, but then the price you charge, you must be free to charge whatever price you want. Exception to that is sometimes in some countries, I can set a maximum price, but I can't set a minimum price, okay? So that's the basic rule, and you can't do it in this context either, all right? Now, that's a real problem. Think about it. In a joint venture, that's kind of a problem, isn't it? Because you and I have come together, we've developed this product, and it's a global, or in our case, pan-European joint venture. And you would think that you'd kind of, because you've jointly done this, you could agree on kind of the pricing throughout Europe. I mean, it's different than a pure supplier distributor situation because there's this aspect to it where they come together. And so there's maybe a little more room to agree on pricing between the parties in this joint venture, is that they can at least, you know, make non-binding recommendations on price, but they still can't, so they can say, okay, this is kind of, we think this is kind of the right price range for Europe, But if you want to sell lower, you can. Okay. And I should also say that this can be a big, in my experiences, this can be a big issue because I'll take an example of a global joint venture. Take pharma. Typically, the profits of a pharma company, they're only at most of them to the United States because the prices are much higher than in Europe. Okay, I'm simplifying. So if you have a global joint venture covers both United States and Europe, your US partner is going to be very unhappy if the prices are much lower in Europe and then it affects the profits. Suppose you have two parties, one American, one European, they have a global joint venture, and they develop a product together, and then the American company is going to sell it in the United States, European company in Europe. But then they have this problem about setting prices of resale price maintenance. I mean, it's a real issue because if the lower European price goes in the US, it really affects the joint venture's profits as a whole. Okay, so this sometimes can be a real issue because it affects the ability of the joint venture to have kind of pricing across various territories. And the best they can really do is set some kind of range that they think they can recommend, but they can't force the parties to apply that range. So another business issue for Iberica, they want to make sure that Nippon, the big multinational, remains focused on this and can't go off working on separate projects in the same area that will threaten the success of the JV. I mean, that's a basic business issue for Iberica, the smaller company. So the question is, can we restrict their R&D activities? And can we prevent Nippon from innovating independently in the field of collaboration? This is what we've already talked about. So you can't restrict Nippon in an unrelated field, but you can restrict them from doing R&D during the R&D phase, but not beyond that. We've already talked about that. Here's another business issue that the business people surely come up with is we need to make sure that Nippon's committed to our product during commercialization, is not selling its own product or somebody else's product. We want, in this field, we want them focused in breast cancer, focused on this joint product. What can we do? You can prevent them from manufacturing or selling competing products, okay? But you can't, in this field of breast cancer, you can't do anything about what they do outside of this field, obviously, okay? So Iberica, its expertise is in injectable therapies, right? So they say, okay, we'll give Nippon a license to use our expertise in injectable therapies for the joint product. But we don't want Nippon, this big multinational, challenging our IP because that's our fundamental product, okay? Injectable technology, and we don't want them, challenging it and having the patent struck down. As we said, you can't have a no challenge provision. The most you can do is say that Iberica can terminate the agreement if Nippon challenges, okay? Another business issue is Nippon initial research indicates that it might be able to adapt its treatment for stage 2 and 3 breast cancer for treatment for certain rare ear diseases. And that could be a very lucrative opportunity. So what can they do to protect themselves? They can put a field of use restriction saying that Iberica can only use this for cancer, leaving Nippon free to use its technology outside of cancer, okay? Outside of breast cancer. So you can put a field of use restriction in. Okay. Any questions on joint R&D? The rules are very technical here. And if you're doing a joint, a joint R&D, you need to go look first at the horizontal guidelines and then read the block exemption 3 or 4 times before you start advising, because the rules are very technical. Remember, you've got the hardcore list, the excluded restrictions, plus, and this is different from most of the other block exemptions, plus you've got these conditions that you've got to meet to be eligible for the block exemption, okay? But even if you're outside the block exemption, your risk is probably going to be low, both because you don't necessarily need to qualify for a block exemption, but because you're in the R&D area. Where I think the greatest risk you would have in an R&D agreement is, there are 2 areas. One is if it's affecting innovation in the sector in a negative way, like we've talked about, or if these companies, if the commercialization stage of selling the product, if it really hurts competition at that level, then you might also have an issue. All right, let's take a 10-minute break and then we'll talk about buying groups.
1, 2. And this is falling asleep. What? Thank you.
Okay, I know this is going to be disappointing news to you as it's Friday afternoon, but we will not be going till 6 o'clock. Yeah. I hope that's okay, Vivian. Or Fabien. I think Fabien and Vivian have already left early, so they don't care. Okay. But this last part is going to be much shorter than what we've been doing. I'm still here. No, still here. Okay. This last part is going to be a lot shorter than what we've done before, but was completely switching to different topic of buying groups of joint purchasing. So, you know, what is joint purchasing? Joint purchasing is when companies come together to purchase input upstream, right? And it can be a joint venture, you know, or it can just be that they have some kind of contractual arrangement. It's just like the other things we've talked about, except here the difference is they're going upstream, if you will, instead of looking downstream, all right? What would you see as a benefit of joint purchasing from a competition or an economic standpoint? Better prices. So you know, by coming together, you might have more negotiating power vis-a-vis the supplier upstream. Okay, that's obviously the main advantage of it. Okay. What problems would you see? Okay, so one problem would be that you get better prices, but you don't pass it on downstream in terms of lower product prices. So, you know, that might be one problem. And of course, if for that to happen, it probably suggests that downstream, you being the members of the joint purchasing have market power, so you don't need to lower your prices. So that's one potential problem. What's another potential problem?
Foreclosure?
Yes. Yes.
That was it.
I didn't hear you. Did you hear?
Yeah, I asked, I said foreclosure, and that was it.
Foreclosure. Okay. Foreclosure. Okay. Maybe, yeah. So foreclosure, I'll just try to interpret foreclosure. Foreclosure means if I think what you're saying is that, okay, if I'm buying upstream, that is, the joint purchasers come together and they're buying from someone upstream, how would that be foreclosure? It would be because they would be buying from one supplier and it forecloses a potential outlet for other suppliers. That's one type of foreclosure that could occur, okay? So suppose that a joint purchasing group would represent a lot of the purchasing power or you know, buying 50% of all of the product. And so if they enter into an exclusive agreement with an upstream supplier or they do joint purchasing, the other suppliers upstream may have less outlets. Okay, so that could be a form of foreclosure. Okay, which then requires those upstream companies to charge a higher price to make up for the loss of the potential customers. I'm just thinking out loud, okay? And the extent to which you'd have that, or which it's a problem, depends on the market shares, obviously, of both the purchasing group and the upstream suppliers. So when you're thinking about joint purchasing, and you've got, when your client wants to do a joint purchasing arrangement, you've got to understand what are there are various markets that you've got to think about. You've got to think about, you've got the buying group, you've got the purchasing market, which is the market they're buying on. So what percentage of that upstream market do they represent in terms of purchasing? Are they buying 50%, 10%? So that's one market you have to worry about is, their purchasing market. You also have to worry about the downstream market, their selling market, okay? And so these are the, this purchasing joint venture is a little more complicated because you've got these different markets you're worrying about. It's different from the other joint ventures where we're looking downstream always, okay? Another kind of foreclosure would be, and I'm just thinking out loud, would be the other potential purchasers of the input might have fewer suppliers because the joint purchasing group is tied up a significant source of supply upstream. And that could be a problem, okay? That could affect prices on the market, for the input. So foreclosure is definitely a problem. Any other problems that you see? Another potential problem could be that you've got your joint purchasing. Suppose that, the participants in the joint purchasing joint venture are significant players on the downstream market. If the input they're buying represents a significant portion of the total price of the downstream product, say it's 80% of the, the material, the raw materials constitute 80% of the cost of the final product, that could be a problem because by the joint purchasing, they are having common costs, which then leaves much less room for price competition downstream, okay? So to maintain them as much competition as possible, you might not want them to come together to jointly purchase. You want them to be competing on the purchasing, so they're competing on trying to keep their costs down, okay? We're gonna go back to some of those things in a minute. I just want to kind of get those general points out there of what, potential issues there might be. Yeah, someone raised a point. Another good point is there's a general risk of collusion, which is another issue that we're talking about here. Is sometimes difficult to tell the difference between a legitimate joint purchasing agreement and an illegal cartel. And there are a number of cases, of cartel cases, that kind of look like joint purchasing cases. One of these cases, Dutch bitumen, I was in for many years, is a cartel case. My client was a bitumen supplier, and they agreed with other bitumen suppliers on a price. So it was a typical cartel, okay? But they were arguing that we're coming together, the road construction companies were agreeing on the price with their bitumen suppliers. So all these companies, all the bitumen suppliers get together and agree on what price they were going to charge the construction company. Construction companies get together and agree, what they're going to buy it for. So there's a negotiation between two blocks of companies. Okay. The problem is that this is all secret. So they would have their secret meetings before. I mean, these guys were not rocket scientists. Okay. They have their secret meetings before their big powwow between the two groups and agree on what product. So that, you know, basically oil companies, we're talking about the bitumen suppliers, all the big oil companies would get together in a room in Rotterdam or whatever and decide, okay, tomorrow we have our meeting with the road the road construction companies. And this is what we're going to do in that meeting. You know, and whereas normally what they should be doing is competing among themselves, who could sell the bitumen at cheapest, and the road construction companies should be competing among themselves on buying it, but that wasn't happening. Okay, and their argument in the case was, this is a legitimate joint purchasing agreement. We're just coming together, the road construction companies, and jointly purchasing. The thing is, though, that there's no the difference. Not always obvious. If you go look at these cases, it's not always obvious. If you look at the facts of the case, what makes this different from joint purchasing, this legitimate, is that there's no integration of what they're doing. They're just agreeing on the price, and they're not combining their volumes or anything else. They're just, you know, they're just negotiating a purchase price, but they're each going purchasing separately. So they're not getting this benefit really of coming together and pooling their volume so they can then negotiate better upstream. And there's no real synergies or efficiencies that's being generated by this. But I have to say that, you know, if you go look at these cases, that line between legitimate and illegitimate is not always obvious. Okay, so you have to be careful. So assuming that you don't have a disguised bitumen cartel, okay, in the guise of joint purchasing, then you have to see, you know, whether you've got a problem. And you've got two aspects of this. You've got the horizontal aspect. This would make these things more complicated. You got the horizontal aspect because you've got the different competitors coming together, but you've also got the vertical aspect of going upstream to do your purchasing. So it's horizontal and vertical. You first look at the horizontal aspect, okay? And then you also have to look at the vertical to see if it's okay under the vertical rules, okay? I mean, the horizontal part is what's driving it, because the greatest competition risk is at the horizontal level, because the thing that any kind of horizontal agreement, the reason it's got a risk is it could be a cartel, because a cartel is at a horizontal level, whereas a vertical agreement is rarely going to raise a, I mean, cartel is the worst kind of competition law violation. Competitors coming together set prices. Vertical agreements rarely have the same potential for a competition law problem, except in Europe, the main thing with a vertical agreement that could be problematic is you divide up territories, which is a terrible thing to do because of the common market, okay? But that's the main risk of a vertical agreement. But the main point here is that you've got to look at both. My microphone is fading in and out. That's not the microphone, it's probably me moving. Right, that's Valentine. Grace doesn't like my slide. Someone's drawing on my slide. I don't know how you can do that. It's okay. Okay, I won't take off points yet, Gracie, even though we can't see you. Can we see her? No, she's hiding. She's drawing on my slide and hiding. Huh? Yeah, it's Gracie, right? Yeah. We can see that you're doing it, huh?
Sorry, I don't know what's wrong with this.
Well, okay. We'll let it go this time. We've talked about these efficiency gains if you pass it on consumers. the downward pressure on the prices upstream. It could intensify competition downstream in the sense that if you're buying certain input together, you've got to compete on other things. So it could increase your competition on other aspects, okay? You can't compete on raw materials because you're buying them together. So that means you have to compete on quality or something else, okay? So it could be good. It could also increase innovation in the sense that a purchasing group could, because it's going to have more buying power, could put pressure on the suppliers to innovate more and come up with better products, okay? The concerns, and we've talked about these already, you could have collusion downstream because your costs are, first of all, your costs become somewhat more similar, but also in the context of the purchasing joint venture, this is the same issue we've talked about already, about information exchange in a joint venture, is here you could be exchanging information in your purchasing joint venture about prices downstream. So you're gonna have to make sure that if you do a purchasing agreement, that you only are talking about the purchasing aspects and you're not sharing information about anything downstream, okay? About your prices downstream, your markets, your strategy, that you need to basically put it another way, segment off, wall off your purchasing managers from everybody else. The people dealing with the joint venture are not sharing information. We're not even talking about other matters, okay? And you may need a lawyer in the room to ensure that, where, you know, they get together, do joint purchasing. You may need to make sure that that's all they're ever talking about. We've already talked about the issue of buyer power, of either on the upstream market or the selling power downstream. It's kind of what I just said, but there's a question about, okay, if you want to minimize the horizontal risk, should you only discuss certain things together, like, I guess, volumes? I mean, you'd have to discuss prices. It's the whole point of this is to get a lower price, right? So I think necessarily you would be discussing prices, but I agree with, I mean, the question is saying, well, maybe there's some things you wouldn't want to discuss that could lower the risk. And I think that's probably true. You could say, okay, we're going to go jointly negotiate a price. I guess you would have to do that. You would have to tell the supplier, you would have to say, okay, we're going to, I mean, you know, in a normal negotiation, the supplier going to say, okay, I'll give you this price, but you have to buy this much, right? But maybe you could say, okay, together we're going to buy at least this much, but you don't necessarily disclose to your partner exactly how much you're going to buy. And that would be better. I mean, the less transparency you have, the better. But to achieve some of the benefits of the joint purchasing from a business standpoint, you can't be completely transparent. You know, you're going to have some transparency, certainly on price.
Well, thank you. It was really helpful, but for example, you could talk about target prices only. For example, you discuss certain volumes, and then each individual party would contact the supplier and, for example, ask for two different quotes. One quote would be under the scenario that you purchase alone. The other scenario would be you purchase a certain volume, but additionally another party, your horizontal competitor, would also purchase a certain volume. In this case, you would only receive the quotes individually, and the other party wouldn't have the individual quote. and also not know your individual prices. This might be a scenario in cases where you have a very similar cost structure, but but there is pretty little guidance in my view when you would need this additional safeguarding.
Yeah, I mean, I'm not sure I follow all of your example, but I agree that you can have a whole lot of different scenarios where you may not be doing everything jointly. And I guess my only comment is there's certain extent the supplier is going to require you to do certain things jointly. Otherwise, it's not going to give you a better price. So, I mean, it's logically at some point you're going to have to do something together, which is what causes the competition law problem. But I agree with you that you don't necessarily have to do everything together. And there are many different scenarios you can dream up, but the thing you have to focus on is where they are doing something together, what effect is that going to have? And that's the part you have to really focus on from a competition law standpoint. I hope that answers your question. We said earlier, one issue that's the commission will look at, or competition authority will look at, is, to what extent this joint purchasing results in commonality of costs, and whether or not that's going to be a problem. It's going to be in function of their market power downstream. If they have no market power downstream, it doesn't matter so much. If they have a lot of market power downstream, it matters more. And the other big area of concern, as we've already said, is information exchange. You've got to be very careful of that, because there's first the initial issue we raised of this can look like a cartel. So you want to minimize the information that's being exchanged, especially minimize information on anything outside of the joint purchasing. Again, these are concerns that we've already talked about, whether or not there's incentive to pass on the savings downstream, which is a function of their market power. That they could force, another issue is they could force the suppliers to reduce the range or quality of the products they produce. So they may, one problem could be that the joint purchasing group says to the supplier, I want this specification. And if the supplier is a big supplier, okay, the fact that they then have to gear their, I've had this issue before. They have to then gear their factories toward this one specification. It could make it more difficult for that supplier to supply anybody else, because other potential buyers may need a different specification. So again, you're thinking about what is the effect of the joint purchasing on competitors at the buying level in this case. So you have to think about that always. In this case, because you're agreeing on specifications upstream, that could have an effect on the others that are buying. You follow me? And then, as we said already, another issue is your other buyers may have a problem because the joint purchasing arrangement may foreclose them from the best suppliers, okay? And whether these issues are significant or not largely depends, as we said already several times, on the market power of the different players at the different levels of the market, okay? You got the horizontal guidelines. There's not a block exemption, but you have the horizontal guidelines that gives some safe harbors, 15% on the upstream market and downstream market. But again, even if you exceed these thresholds, it doesn't necessarily mean there's any kind of presumption of anti-competitive effect. And this is a case of other joint ventures. if the geographic markets are separate, you obviously don't have a problem. It's only when you're in the same product and geographic market. So there are several cases. I've given you a few cases. One case shows the commission looks closely at restrictions placed on the ability of the members of the group to obtain supplies outside of the group. So in this Rennet case, which is an old case, but it's one, you know, there are not that many cases in this area. So when you start talking about joint purchasing, often you go back to some of these older cases. This Dutch cooperative required the members to purchase all of their rennet, which is used in making cheese, exclusively from the cooperative, and they couldn't buy it outside of the cooperative. The commission said, you don't need that kind of restriction. It found that this exclusive purchasing obligation went beyond what was necessary and prevented competition supply of rennet, okay? You've also got a case on sulfuric acid. The members of the buying group made sulfuric acid, and they came together to purchase sulfur. And they had to purchase it exclusively through the group, and they couldn't buy the sulfur and then sell it to non-members. And they could only use the sulfur they purchased to make sulfuric acid. And the commission made them change it so that they brought down, they didn't have to buy all of their sulfur, only 25% through the purchasing group. And they were free to sell to non-members if they wanted to, and they were free to do what they wanted with the sulfur. So, you know, bottom line of this case is you can impose restrictions related to the exclusive purchasing, but you have to be careful about other kinds of restrictions kind of on the periphery of that. Then you've got slightly more recent case, still an old case, of a Danish cooperative, which involved farm supplies like fertilizer. And it said, okay, the members of this group can't go off and become members of a competing organization. This actually went to the Court of Justice, and you know, not very helpful. General principle is you can't impose restrictions go beyond what's necessary for the joint purchasing, the cooperative. So it has to be limited to farm supplies, which kind of makes sense. That doesn't strike me as odd. But importantly, the members of the joint purchasing organization could, if they wanted to, they go purchase outside of the joint purchasing organization, okay? But frankly, in each of these cases, they depend very heavily on the facts. And so when you're looking at joint purchasing, the first thing you've got to do is look at the two levels of market you're dealing with, understand how many players there are on the market, and then ask yourself, what's the effect of the joint purchasing on that market, okay? And how does it affect competition on those two markets? And joint purchasing, again, I find more complicated than the other kinds of joint venture because you've got these different levels you're thinking about. You're thinking about upstream, you're thinking about competition on the market at the joint purchasing level, and then you're thinking about downstream. You actually have three levels of market you're thinking about. And that's what makes this more complicated. Okay, that's it. I know you're disappointed. You're leaving early on Friday, but before we stop, are there any questions? But that's okay. It's Friday afternoon. You can relax. Don't worry about it. Yeah, I mean, that's a good question because I always struggle with this. Is the commission says, "Oh, you must pass it on," but I mean, you know, the companies that come together in a purchasing group, yeah, they're trying to get lower prices upstream, but the reason they're trying to do that is to increase their profit margin. So they may not necessarily want to pass it on, right? Right. I mean, they may keep the price downstream the same and they get the benefit of the lower price of the raw material, right? Yeah, right, right, right. And I agree with your comment. Is I've always struggled with this. And I think that the real issue, the commission is missing the point. The real issue is not whether who gets the benefit of that, because I think it's unrealistic to expect these companies to pass all of that downstream. I think the real issue is if they've got significant market power, is this, are they having commonality of cost that then takes pressure off on price competition downstream or something? I think that's the issue. And it's not, I mean, if you read the rule, they say what I just said. They say, okay, you got to pass it on downstream. But I think that that's unrealistic. And I think it's very esoteric and academic to be asking companies to pass it on downstream. Okay, so in practice, I don't think that's such an issue. I think the issue is going to be, by coming together, are they going to exclude suppliers upstream? Are they going to make it harder for their competitors to get input, get raw materials? Or are they somehow, because of this joint purchasing, going to hurt competition downstream, either because they're colluding or because they have high commonality of cost? I'm not aware of a case. I mean, you hear this a lot about in this kind of situation of you should pass on this savings downstream. You're not a competition problem, but I'm not aware of cases. There may be cases, but I'm just not aware of where this has been an issue. And I agree with your comment that it seems to me that in real life, it's unrealistic to expect the company to, realize savings in its production process and necessarily pass it on downstream. Of course, if they don't pass it on downstream, it suggests that downstream there may not be enough competition. And then the question is, does the joint purchasing, does that contribute to that lack of competition or not? Yeah.
Value from the companies as a member of buying alliances. And the fact that, yeah, we just buy products and resell and sell them to the customers, but we have no added value in the chain except that we put those products together in the shop. So I guess that situation is more.
Yeah, if there's no added value, I would see more of a competition problem, because because then it's total commonality of cost almost, right? Because if the question is, okay, you have joint purchasing and they're just assembling, for instance, components. Well, obviously there's a problem. Why? Because there you have very high commonality of cost, which we said is one of the main factors you're looking at. And if you have high commonality, I think I did research on this a few years, maybe 20 years ago, actually. And the case law said the commonality of costs, at the time, the case law was saying, I think it was 35%, 40%. If it's higher than that, it could be really problematic. Okay, but that case law may have changed since then. But you can imagine if you're just assembling components, it's almost 100% commonality except for the labor involved in assembly. And so it would be likely be a problem. Yeah. Right. Right, exactly.
Depending on sector.
Okay. Okay. If you have questions and if, you know, as you haven't thought of, you can always email me and I'll try to respond. But it's been a pleasure talking to you and seeing some of you, not seeing others. And so I guess, you know, I won't see you on the exam, but I will give you an exam. Okay. Have a good weekend.